Welcome, Facebook viewers. Uh, my name is Brad Bodis. I'm an attorney with the Bond and Bodis Law Offices, and we bring you this Facebook Live every Wednesday at 1 o'clock p.m. Central Time. We really just like to touch upon issues that we think will be important to consumers and people that might need our assistance. Today, we are very fortunate to have a good friend of mine and an attorney that is known nationally and does work both nationally and internationally. Um, uh, Josh is known as the student loan lawyer. Josh Cohen, Josh, you practice out of Vermont, correct? I know you're licensed in both Connecticut and Vermont.
Correct. I'm based in Vermont. I moved up here in 2012. I started my practice in Connecticut. That's why I have both.
So, for our viewers, at the Bond and Bodis Law Offices, we help people with money problems. And one of the areas that we see a lot of people having problems with are with student loan debt. In fact, it's the second highest, second most significant type of debt that people face in this country. Millions of individuals with student loan debt, and a lot of people that have a hard time maintaining student loan payments. Um, I will tell you a few things about our guest, and then I'll let him give a little bit more background. So I first met Josh about 10 years ago, I think. Josh, you were speaking at an NC National Consumer Law Center conference, and I said, "Who is this young guy? Who is this young guy? He knows so much about student loans." And you really burst upon the scene, and you've developed such a great reputation. But for background purposes, Josh got his bachelor's degree at Brandeis University. That was back in 1996. You then got a MBA from Phoenix University in 2002, and then went on and got your law degree from Quinnipiac University School of Law. That was in 2007. Again, somewhere, and I believe it was 2011, just looking back at my records, I believe it's the first time I met you, Josh. You popped on the scene and you were giving a talk at the conference to attorneys from all over the country about student loan law. And since that time, you've just developed such a reputation. I know people from all over, attorneys and consumers, reach out to you. So I really appreciate you joining us today.
Oh, well, thank you for the invite. Happy to talk.
Tell us just a little bit more about your background and how you got into this field, Josh.
It's just a matter of all of the circumstances falling into the right place. When I was an undergrad at Brandeis University, my work study job was in the financial aid office. So I would take calls from prospective freshmen who wanted to know about their financial aid. Never thought anything further would come of it. I have a degree in psychology. So,
Sounds like a good pre-law degree.
It was. And the truth of the matter was, law was never on my radar, honestly.
Okay.
Law fell on my radar in about 2003, it was about 2003 after I finished my MBA. I was living in Orlando and I was working at a school for youth offenders. That's the politically correct term for them. Juvenile delinquents, but youth offenders. I was the business manager at the school. I was in the number 2 position. And I was told that I didn't get any kind of education bonus or raise for getting my MBA. And I was newly married, and I realized I was topped out in my salary at $35,000, and that's not where I wanted. I knew I wanted more. I had a cousin that had just been accepted to law school. She and I were talking, and I realized, you know what? I could do this. I think I'm interested in this. And I was interested in consumer protection, but I had no further idea what I would do with it. I took the LSAT. I did well enough, got partial scholarship to Quinnipiac. My uncle and sister had attended there as undergraduates. So I ended up at Quinnipiac. It was a chance to get out of Florida and back to New England, which is what I wanted, vacationing up here all the time. During law school, I did a brief stint over my 2L summer at Legal Aid in Waterbury, Connecticut. And that's where I learned about consumer law and really practicing it. I learned about the FDCPA there, Fair Debt Collection Practices Act. But we also had a gentleman come in that had a student loan problem. I was actually working for something called the Consumer Law Project for Elders. Anybody over age 65 automatically received help for consumer law issues. It didn't matter what their income was. This gentleman came in, his Social Security was being offset. He was in his 80s. It was being offset because of a student loan that he hadn't paid in who knows how long. He had been a long hauler, a truck driver. So, bills happen and you lose track of things. And like today, back then, the Department of Education wasn't always diligently collecting debts. And it sat there. But I heard student loan and I popped up. I said, wait, I know what to do. So they gave it to me because, it's not the run of the mill thing. I referenced NCLC's Student Loan Law Manual, National Consumer Law Center, verified a few points. By the end of the summer, we had him out of default. He was making payments of $5 a month, keeping his Social Security intact. Everything worked. But from there, I also landed a job with a consumer attorney in Connecticut by the name of Dan Blinn, where I learned FDCPA and more motion practice and things of that sort. I stayed with Dan through my 3L year. And after I passed the bar, we decided to part ways. And Dan is still a mentor for me. I think he does an excellent job with that. But I went off on my own. And I took 2 cases from Dan that were student loan issues. They blossomed into my first class action when I was only 9 months into practice. And wow. Dan helped me. He does class action, so he came in and helped me. And it was the first of its kind. We spawned, I think, 6 or 8 copycat class actions off of that. And that's where I really started getting into student loan work because it fell on me. I started talking to other attorneys who thought I was nuts for doing it, but also gave me their files because they didn't want to do it. And that's really how it grew. It was just, I became the student loan lawyer by default because nobody else was doing it.
Right.
And I became known across the U.S. I was getting calls from bankruptcy attorneys in states I'd never been to, still helping these folks. And then you and I, Brett, met at the first NCLC conference I ever went to. It was Chicago. I remember that one.
Right.
And yes, that was in 2011, very first one. And I remember I was in the back row actually answering questions under my breath. You turned around and said, you know a lot about this stuff. And
exactly.
That's how it started. But the student loan work is because no one else wanted to really dive into it. Everyone else has already got their established practices. 2011 is also when I launched my workshop teaching other attorneys how to do this. Because it works so seamlessly with bankruptcy practice and other debt management practices, right. Consumer law. So that is the long-winded, how did I get here?
Well, for our viewers, again, Josh is known nationally as the student loan attorney. And I apologize to our viewers. We seem to be getting a little bit of feedback. So at the Bond and Bonus Law offices, we help people with money problems. We have offices throughout Alabama and throughout Mississippi. And if a lot of people after this past year and a half are having financial problems. If you're having financial issues, mortgages, foreclosures coming out of forbearance, student loans coming out of forbearance, we encourage you to reach out, be proactive. We're offering absolutely free initial consultations. If you want, we'll do them by phone or video from the comfort and safety of your own home. But reach out and be proactive, be prepared to address some of these problems. Josh, we did an episode just recently about the fact that the foreclosure forbearance period is coming to an end, and a lot of people worried about house payments that they've missed. But it made me think, just about everyone we see, certainly a large percentage of folks that come to see us also have outstanding student loan debt. During this pandemic, there has been a forbearance, at least with federal student loan payments. We're going to learn more from you today about when we can expect that forbearance period to come to an end, what it means. And we just want to talk to people about student loans in general and what some of the things are that can be done. As a bankruptcy attorney, with the bankruptcy process, my hands are somewhat limited. Most people know that you can't typically just discharge a student loan in bankruptcy. There is a hardship discharge exception. Sometimes we can do things through a reorganization, Chapter 13 type bankruptcy to help with student loans. But Josh really is the expert, and we will include Josh's contact information on the screen here throughout this interview today. If you need to get in touch with somebody that can really help with student loan issues, Josh Cohen is the one to talk to. So, Josh, let's start with this. Tell us what the forbearance on student loan payments really has been, and when do you expect to see an end to that forbearance period?
Thanks for starting there. So this big forbearance that we're talking about falls under the CARES Act, which was implemented back in March of 2020. Actually, it was in April, but they made it a little retroactive to March. The problem was twofold. Really, this forbearance could have and should have been provided by the Secretary of the Department of Education. The Secretary has the ability to do that by snapping their fingers and say, hey, we have a state of emergency. I am declaring that all action stop on student loans. And they did this. The first massive time they did this was after Hurricane Katrina, where they snapped their fingers and all student loan collections of any kind in that area ceased. There were no qualifications. If it was a federal loan, it stopped. And yet that didn't happen this time. So Congress had to step in and say, okay, we created the CARES Act, which had lots of facets to it, but they also created a student loan facet to it, which said, we'll offer a forbearance, we'll stop interest, no collections if you're in default, yada, yada, yada. The problem was, because it's Congress and everything has to be complicated, they made qualifiers. So believe it or not every federal loan was covered by this pandemic forbearance. It was only loans held by the Department of Education. So, for instance, if you had loans with, say, Navient that were not held by the Department of Education, but were actually loaned by Navient or Sallie Mae back in the day, you weren't covered. And there was mass confusion, and they changed the vernacular and said, oh, you have a commercial loan. What does that mean to anybody that doesn't do this for a living? Commercial to me means not a federal loan. And so I had a massive amount of people calling me in April last year going, I thought my loan was federal, but it's not. No, it is federal. It's called a commercially held federal loan. So you don't fall under CARES. You still got to make your payments. Now, to the credit of the industry, many of them hopped on the train and said, you know what, we're going to offer you a forbearance anyway, but all of them terminated it back in January of 2021. So we still had this gray area. When we had a change of guard, and we have the new Secretary of Education, I believe it's Cardona, I believe is his last name, in March 30th of 2021, he snapped his finger and said, you know what, I am making the CARES Act to encompass everybody. So if you had what's called the commercial loans or FFEL loans, now they were covered by CARES. Now they had 0% interest, and he made it retroactive. And if you were in default and you had collections, they stopped all of that. And something very interesting, if someone defaulted between March of 2020 and when that announcement came out, or even till today, if you defaulted because it was an FFEL and you thought you didn't have to make payments, they're reversing that default. So here we have a Secretary of Education who stepped in and said, wait a minute, we're going to fix this. And the process is still slow. They're working out the logistics. But the point here is, if you have a federal loan that defaulted after March of 2020, it is going to be reassigned to the Department of Education. The default will be rewound. If you had any offsets or garnishment, that will be refunded. And we're still seeing the details come out, but that's what happened. So it was from the CARES Act because Congress had to do it, and now the Department of Education is stepping in saying, no, we'll cover everybody. So we're starting to see that mass protection.
So one thing I pick up on real quick in listening to you, Josh, is it's important for people to know what type of student loan they have. And let's start real basic. So there are private student loans and there are federal student loans. Give us a quick explanation of the difference between private and federal student loans.
Very simply, a federal student loan is one that was either administered by the Department of Education, which are called direct loans, because you're getting the money directly from the Department of Education, or the older models, which you can't get after 2010. Those are called FFEL, Federal Family Education Loan Program. That's what started back in 65 and carried through until 2010. Those are loans that are offered by private banks or different guarantee agencies, like mine are from VSAC, Vermont Student Assistance Corporation. They aren't from the Department of Education, but they are guaranteed. So if you run into trouble, your loan will eventually end up with the Department of Education. That's what makes it federal. Compare that to a private loan that you can take from any bank. It is not guaranteed by the Department of Education, and it will never be guaranteed, or it will never, ever end up in the Department of Education's hands. That's the difference. And what that really means for us is, what happens if you run into trouble? When you're paying the loan, there's no problem. It's all about what can happen to you if you have a problem. That's the big difference. So again, federal loans have the government behind it. Private doesn't.
And is it too simple to say that if it's a federal student loan and you get into trouble, there are a lot more options available to you than if it's a private student loan?
That's exactly true. As troublesome as the collection powers are for federal loans, it is the only consumer product I know that has a fail-safe. You have the ability to fix your mistake, to get it out of default, or curing, as we call. In fact, there's two different methods for it. So you could really run into trouble twice and get out of jail twice with the federal loan. A private loan, just like a credit card. If you go too long and after 6 months or so, it's dead, it's defaulted, and you can't fix it. You either pay it or you visit Brad and find a way to work through bankruptcy. Yes, big difference.
Okay. So what I want our viewers to understand is the first thing you need to do is you need to figure out what type of student loan you have. If it is a federal student loan, there's then another layer because there are different types of federal student loans, as Josh explained. And I think it's important here to stress that, Josh, whenever I get into a conversation with somebody about helping folks with student loans, there's this immediate, well, people should pay their student loans. I had to pay mine, and I did pay student loans, and you probably did too. Well, we're not talking here about student loan forgiveness. That's a whole nother topic. It's something we'll leave to the politicians right now. But you and I both help people that are unable to pay their student loans or other bills as they become due. And student loans are a special category because typically a student loan cannot be discharged in bankruptcy. Josh, I met a year ago with one of our congressmen and his staff to talk about actually forbearances at that point before there was, and there's still not clarity as you explained. But the first reaction was, we don't want to just forgive student loans. I said, no. I said, student loans are important because as a bankruptcy attorney, there's usually not a whole lot I can do with student loans. And he said, you mean student loans aren't dischargeable in bankruptcy? And I had to explain that no, they're not typically dischargeable in bankruptcy. So, Josh, generally, student loans are different from any other debt primarily for that reason, primarily because you can't deal with them in bankruptcy. So what is the first step somebody should take if they have a federal student loan and they're unable to make their payments?
So I want to take one step back. We talked about federal versus private. I want to give a resource The first place anyone should go to verify if they have a federal or private loan is studentaid.gov. That is the Department of Education's website. That's where you can go to find your federal student loans only. If you know you have a loan and it's not there, it's a private loan. And you can always cross-check your credit report to what you find on studentaid.gov. Studentaid.gov will also tell you, is it a direct loan held with the Department of Education, so you're covered by CARES Act, or is it an FFEL loan not with the Department of Education, and now you're covered under the extra layer that they put onto it since March. But this plugs right into your question, Brad. What do you do when you can't afford your loan? Well, they say the first thing you should do is call your servicer. Okay, you can call your servicer. The servicer is supposed to
explain again. A servicer is the company you're making your payments to.
That's correct. Yes, whoever could be Navient, Great Lakes, FedLoan Servicing, Nelnet. There's a ton of other companies out there. They're a servicer. They don't necessarily hold or own your loan, but they're happy to take your money. Right. That's their job. So you should give them a call and see what they can offer you. I'll tell you what they're going to offer you: forbearance, deferment, which you have to qualify for, or they should talk about IDR, income-driven repayment. Some of you know it as income-based repayment. Some of you have heard it as pay-as-you-earn. All of those are particular payment plans under IDR, and there's five different income-driven repayment plans. It depends on, is it direct or is it FFEL? How old is it? Because some of these do have date restrictions. What I tell people to do is go to studentaid.gov, and you can get a lot of information there. In fact, there's even a calculator to help you run. What would my income-driven repayment be based on my family size and my adjusted gross income, or your current income if there's been a decrease? That's really where I like to start, and then call your servicer and say, I was on the website. I've learned about this. How can you help me make that happen? All of this has to be done with the paper application, or you can do it through studentaid.gov, but it's still worth having that conversation with your servicer. The Department of Education for years has said, you don't need help with this. Servicers will do it. The truth is, as long as you know what you're doing and you've done the math, you don't need someone like me. I admit that. This is a self-help system. So start with studentaid.gov, see what you got, run the calculators. That's where I start.
All right. So explain to our viewers what exactly an IDR is. And I know you said you can look to the website, you can determine what payments and all are, but in simple terms, it's a repayment plan based upon your income.
That's exactly it.
But the problem with that is if you're making a payment based upon your income that is less than the interest that is accruing on that student loan, then even though you're making payments, the balance you owe is going up.
Yes.
We call that negative amortization. So you get into an IDR, you're making the payments. What's the next step? Is there a next step?
So here's the thing to understand about income-driven repayment plans. And I get a lot of people who call me because they don't get all the information. So this is where it becomes important. So thank you for this question too. Income-driven repayment is not just about getting an affordable payment, which for most folks is negative amortizing. They are paying less than the interest. And a lot of people panic for good reason, because their $50,000 loan after a few years is now $60,000, even though they're paying it, or it goes from 100 to 150. Number one, interest always accrues. There is no way to stop interest no matter what you do.
Except during the pandemic.
Exactly. This is the first time we've ever seen that. Thank you, Brad.
That's right.
So the interest is always accruing. So your interest might be $100 a month, but you're only paying $50, so it's still racking up. Here's what people need to understand that servicers inadvertently forget to tell them. With any income-driven repayment plan, there is forgiveness if you are on the plan anywhere between 20 to 25 years. It depends on which particular income-driven repayment plan you're on, but they're all 20 to 25 years. That means whatever balance is left after the 20th or 25th year is automatically forgiven, written off, gone. Here's the catch. Right now, the way the law is written, the borrower will receive a 1099-C, a cancellation of debt. Does that mean it's taxable? Only your CPA can tell you that, because there are things that CPAs do that are magical. That's not what I do. But there are ways that you might be able to reduce the burden. The other question is, how old are you going to be when you get forgiveness? Are you going to care about taxability if you're 85 when you receive this thing? You know, that's the other issue, is forward looking. I get a lot of people that are nervous about receiving a tax bill for $250,000. You're not getting a tax bill for $250,000. Let's say, and I use large numbers because my clients average $75,000 to $200,000 in student loan debt. That's
Right.
a lot. And so people, they do the math. They say, well, I'm going to get, $150,000 written off. That's not your tax bill. That's how much you have to put on the paperwork. Talk to a tax attorney or a CPA. They can calm your nerves. Or talk to a certified financial planner. They're very good with this stuff. My point is, take it now so you can survive for the next 20 to 25 years. And are you kicking the can down the road? Yes. Does it become a slightly bigger snowball? Maybe. We also don't know what's coming down the pike. And eventually, I know we're going to talk about some things that we're seeing out of the new Department of Education. I'm very hopeful that things are going to look much better in 20 years or so.
Yeah, I hope that to be the case also, because I know how many people struggle with student loan debt. Something I want to make sure that I simplify here that Josh just talked about. Most people don't understand that when a debt is forgiven, whether it's a student loan debt, whether it's you've negotiated some kind of settlement on a credit card, whether it's a mortgage debt, if a debt is forgiven, in most instances, the IRS says that's income. And again, we're not going to get deep into the woods as to the tax implications of that. But you need to be aware, if a debt's forgiven outside of bankruptcy, it's generally deemed to be income and thus taxable. So although you may be getting rid of what you owe on your credit card or your student loan or your mortgage, you may have a big tax bill. So it is so important to talk to a tax professional about the implications. All right, so Josh, say I'm a student loan. I have student loan debt. I've been unable to pay it this last year. It's been tough. At some point, that student loan is going to become due and payable again. I've determined that I have a federal student loan, and I've looked at what my IDR payment should be. First step is to contact the servicer then and talk to the servicer about getting enrolled in a program. Is that correct?
So in order to get enrolled, you have to do paperwork. So you can either call your servicer, or sometimes just on their website, you can get the application. It's called the Income Driven Repayment Application. Right. If you talk to your servicer, you can have them, they'll email it to you or mail it to you. Or if you go to studentaid.gov, you can download the form there. And I believe you can actually apply online through studentaid.gov, and it will funnel it to your servicer. So you've got a plethora of methods to do it.
All right. So what if I was already behind on my payments? I was in default on my student loan payments. And does that affect my eligibility for an IDR?
It does. So any borrower that is in default cannot have an income-driven repayment plan. In fact, they can't have any of the benefits, or the forgivenesses, or any of that until they get their loan out of default. Now, you can get your loan out of default. The two simple methods are, one is called rehabilitation, where you have to make 9 payments over 10 months. That you negotiate with your debt collector. Easy enough to do. Or the method that I prefer is you can simply consolidate your loan. Now, this is a term of art. Consolidation usually refers to taking a federal loan and refinancing it through the federal government. That's consolidation. If I ever say refinance, I'm actually talking about private loans, which is a very different thing.
Right.
To consolidate a federal loan, again, is a paper application, or you can do it through studentaid.gov. It is not a credit issue, so it doesn't matter what your credit looks like. There's no closing costs or origination fees. There is a fee to get out of default, anywhere between 16 to 18.5%. They tack that on to the back of the loan. And you do have to apply for an income-driven repayment plan at the same time that you consolidate. And that's great, because they do the consolidation, they do the math for your income-driven repayment plan, boom, you're off and running. The process for consolidation takes 30 to 90 days. So for those of you that are in default right now, now is the best time to start the consolidation process, because then you should be out of default by October 1st, which is when the CARES Act is set to expire, which means you won't have any negative collection activity, and you will be ready to make your first payment based on your income come October with everybody else. That now is the perfect time to work on it.
So again, folks, this is another example of you need to be proactive. You need to contact your servicer. You need to do the paperwork that's required. You need to ask questions. And if you can't get these things done by yourself, you reach out to one of us at one of our offices, or people that have a little bit more complex issue. Perhaps you're not in Alabama or Mississippi. Josh Cohen is an excellent resource, and we've kept his contact information here on the screen. Josh, before we get into the next issue, I want to touch on a couple of items that I get a lot of questions of. The first is, people say, well, I understand that student loans are sometimes dischargeable in bankruptcy. So if you're otherwise a bankruptcy candidate, if you have student loan debt, the exception provides essentially that if you are disabled, if you have some condition or some situation that would qualify you for a hardship discharge, then you can get rid of those student loans in bankruptcy. It's a difficult process. It's it's more difficult, I think, than what often the alternative is, Josh. And correct me if I'm wrong here, but a lot of people that would qualify for a hardship discharge in bankruptcy may qualify for an administrative discharge based upon their disability.
Correct.
Talk about the administrative discharge for student loans based upon a disability and how that process works.
Okay, so what you're talking about is called the Total and Permanent Disability Discharge, or TPD, and it's exactly what you said, and it's exactly what the title says. You have to be totally and permanently disabled. It's a very simple application process, and there are 3 ways to qualify. So the first one is, if you happen to be a veteran and you have 100% disability rating from the VA for a service-related incident, all you need is that piece of paper that says 100% service-related disability. You staple it to the application. You mail it to Nelnet, who's in charge of doing all of these, no matter who your servicer is, and you will hear back within 60 days. That loan is gone. That's it. That's the easiest one. The second one, if you are collecting Social Security disability through Social Security Administration, you should have a rating or a review period. If your review period is 5 years or more, which I've heard is rare, but I've seen them. If your review period is 5 years or more, all you need to do is staple a copy of the statement showing your review period is 5 or more. You staple it to the application, mail it to Nelnet, and within 60 days, your loan is gone. For those of you that are not veterans or not on SSDI or have an SSDI review period of less than 5, the majority, you take the application to your doctor, any doctor that you have. And I know that most folks have multiple doctors depending on the severity of their disability. You only need one doctor to fill it out. And the standard is very simple. that you either are terminal or you have something that has affected you or will continue to affect you for a 60-month period or cumulative thereof that stops you from gainful employment. Okay, and that's the simple term. Doctors can look at this and they can fill it out very easily. They know by looking at it, yes, you qualify, no, you don't. And the simple question to have to ask your doctor before you get started is, do you think I should be working? Now, all of you have had this conversation with your doctors. In fact, many times I find people are working against medical advice.
Yep.
Well, here's an advantage, and I'll talk about a loophole in a minute. So basically, if your doctor's willing to fill it out, I don't want to call it a loophole. If your doctor's willing to fill it out, then you fill it out, you send it in to Nelnet, and within 60 days, you get back a decision. That's the first part. And if you are granted a discharge, it's gone. Now, this discharge is tax-free. There's no 1099-C or anything. Tax-free, that's it. So that's good. Now, things to note very quickly. If you receive a discharge not as a veteran, but if you receive it under SSDI or through your doctor, then there's a 3-year monitoring period. And this is where I talk about a loose loophole about employment. On that monitoring, they want to know, have you earned any income? And if you have to send them a copy of your tax return. They're only looking at your portion. If you're married, they don't care about your spouse. You can still file jointly. The benchmark that they're looking for is if you are still working or earning income, you are not allowed to earn more than the poverty index for a family of 2, regardless of what your family size is. Poverty index for a family of 2, which right now I believe is about $17,000. Mm-hmm. That means technically you could work part-time. As long as you earn less than $17,000, you're still good. So don't feel like you have to be completely disabled and you're not allowed to work. $17,000 is about the cap. If you're not working, then you check the box that says no income, gone. And again, this is from earned income from work. It's not rental income. It's not eBay sales. It is work, a paycheck.
Right. The other question I get often is about public service type forgiveness of student loans. And I know you could probably talk about this for quite a while, but give us a synopsis of how that program works.
You know, now's a great time, Brad, because a report has just come out, and I think it's been hitting the papers as well, that public service loan forgiveness still has a 98% rejection rate. And I'm going to break that down in a minute. But very quickly, public service loan forgiveness is a program for anybody that is employed by a U.S. government, whether it's federal, state, county, or town, or if you are employed by a 501c3 nonprofit or a not-for-profit that has a public service interest. Ambulance companies are actually the best example of that. They're a not-for-profit.
Right.
You must be employed full-time, which is whatever the employer defines it as, or 30 hours, whichever is more. Many employers define it as 32 to 34 hours. If the employer says you're full-time, you're full-time. So one, you need the right kind of employer. It doesn't matter what you do, as long as you are employed by them full-time. 2, you must have a direct loan, so go to studentaid.gov and verify. And 3, you must make payments under either the 10-year standard plan, which most of us can't afford, or any income-driven repayment plan. As long as you're on an income-driven repayment plan, that's good. You need all 3 of these, the job, the loan, the payment, for 120 months, all at the same time. The program started effectively October 2007, so any payments after October 2007 count. Once you have 120, which is 10 years, you then apply for public service loan forgiveness. This is a redemption program. It's like when we used to go to the fairs and we go to the Midway and you'd get a ticket from all those games, and then you'd save up all your tickets so you get a whoopee cushion. This is the same thing. Once you have 120 tickets, 120 months, then you go to the Department of Education and cash it in for forgiveness. And anything not paid within those 10 years is forgiven, tax-free, done. That's it. Sounds simple.
Yeah, the next question was why such a high 98% you said of applicants don't qualify.
Okay, so here's what's happened so far. First of all, since payments only started counting as of October 27, no one qualified for forgiveness until October of 2017. We had an administration that wasn't very helpful, that was actually trying to kill the program. With the new administration, they're working, but not as fast as they can. Now, I don't want to call them the gatekeeper, but there's a company called Fed Loan Servicing, which is a servicer. They are charged with tracking the qualifying payments. One of the problems they've had is they don't get to see the records of your previous servicer unless there is a request to do so. So many people are seeing that they only have 14 payments counted when really they should have much more because they were previously with another company. So that's the hint of one problem. Now, your loan doesn't get assigned to Fed Loan unless either one, you consolidated with Fed Loan, or two, you fill out what's called an employer certification form. And you do that every year. And that sends a message to your servicers, wait a minute, this guy's doing PSLF. They transfer your loan to Fed Loan. Now Fed Loan starts tracking. Now they're trying to get the records from the other servicers. That's slow going. So that's one problem. Two, there's actually an old servicer that doesn't exist anymore that was an abomination. That was, instead of putting people on an IDR, they put them in forbearance. So people thought they had a $0 IDR that was counting. Nope, they were in forbearance. Forbearance doesn't count. Or people were making payments, but still on a forbearance. And they weren't tracked right. So that is a nightmare that is unfolding. So that's one piece of it. Another piece, only direct loans qualify. Many people didn't realize this until they were in their 9th or 10th year. And then you have to consolidate and bring your loan to direct loans. You don't start qualifying until you have a direct loan. So anything before that doesn't count. Three, and the most annoying one, you were in the wrong payment plan. Many people are on what's called the 25-year fixed plan or even the 25-year graduated plan. That's not based on your income. It is a literal amortized plan to pay off your loan. Now, so if you're in the wrong payment plan, those payments don't count. There was a fix made if you were on the wrong payment plan. It's called TEPSLF, Temporary Public Service Loan Forgiveness. Now, that's been in existence for 2 or 3 years now. With that one, you have to show that the payments you made were as much or more than it would have been had you been on IDR. Now, that's already a facepalm. We know that's not really the truth. The reason why people took the 25-year plan is because it was cheaper than the IDR.
Right.
How does that happen? Here's my rule of thumb for IDR. You can have IDR. It will help you if you make less than what you owe. Now, for the majority of people on PSLF, that's true. They may owe $70,000 or $100,000, but they only earn $50,000. So IDR works for them. Reverse it. What if you only owe $30,000 a year, $30,000, but you make $70,000 a year? You're not going to qualify for public service loan forgiveness because you're going to pay your loan off before the 10 years comes. Is that unfair? I'm not here to discuss that. But that's really, so a lot of it is people are applying, not realizing they're missing something. Now,
Right.
Is it their fault? No, the servicers have done a terrible job, and the Department of Education has done a terrible job with public relations on this program.
But it's another instance, and I keep repeating this, folks. You can't just make assumptions. You can't just assume that you're in a public service type profession that your student loan is going to be forgiven. As Josh just emphasized here, there are a lot of boxes you need to check to make sure that you're going to qualify and that your student loan is going to be forgiven as you expect it to be. I want to take just a short break here, just to recap. My name's Brad Bodis. I'm an attorney with the Bond and Bodis Law Offices, where we help people with money problems. We're located throughout Alabama. We're located throughout Mississippi. We know a lot of you are having financial problems right now. It's been a tough year and a half. We're offering absolutely free initial consultations with an attorney, with an experienced attorney, and we'll do it by phone or video, however you're comfortable right now. We want to help, and you need to reach out and ask questions about what your options are before you get into trouble. Today, we're very lucky to have one of the top student loan authorities in the country. In my opinion, Josh Cohen has become known as the student loan lawyer, not only by his clients, but by professionals, other attorneys all over the country. He has an excellent reputation, he has excellent practice, and he's been kind enough to share some important information today. It's important for our viewers to know, these Facebook Live broadcasts live on our Facebook page and they live on the Bond and Bodis website. So if you know somebody that can benefit from what Josh has had to say today, please share this episode with them. Encourage people to listen so that they know how income-dependent repayment plans work, how public service forgiveness works, how if you're totally and permanently disabled, how you might qualify for forgiveness. There are all kinds of important things to know about your student loans. It's very important to reach out for help. Josh, we do have a couple of questions that have come in from some of our viewers that I want to pose to you. And then I'm going to finish up by talking about what we can expect with student loans in the future. I don't have time to get to all of these questions yet, but let me pick one or two here. So this is just a very general question, and I think you've addressed it, but what will happen if I can't make student loan payments when the forbearance period ends? What's going to happen?
So to answer the direct question, what's going to happen is if this is a federal loan and it defaults. Now, let me back up. A federal loan doesn't default when you miss the first payment. You have to miss 9 payments for a federal loan to default. So you've got time to fix it or find someone who can help you. If you end up defaulting, the government has quite a few tactics. Very draconian, but they have a few. They can garnish wages without a lawsuit. They can take 15% after taxes. They can, if you collect Social Security, they can take 15% of it, but they have to leave you with $750 a month. If you receive a tax refund, they can take it and apply it to the loan. Those are the big 3. They will, of course, hire a debt collector who will call you. They do have the ability to sue you as well. And I got to tell you, those lawsuits are a bit scary, especially if you have a direct loan, because your government's held with the Department of Education, which means you're sued by Department of Justice. You get a lawsuit that says the United States of America versus you. You're being sued by your country. So wage garnishment is really the big one that hits people. Nobody likes to lose control of their own money, and that's exactly what a wage garnishment does. And this wage garnishment has priority over a judicial wage garnishment. So if you've been sued by a credit card company and being garnished, the Department of Education gets priority there.
And you just made an excellent point. There's no lawsuit required before the garnishment starts with a student loan type garnishment. Now, in Alabama, and I expect nationally, it's a smaller percentage than a traditional garnishment. It's 15%, but 15% of your paycheck starts disappearing. It's a big problem.
Mm-hmm.
So reach out to somebody for help before you get into trouble with student loans. Another question here. What if I have a cosigner? Now, I assume that if it's a cosigner, it may be a private student loan or there may be a parent plus type situation here. Explain how that works, if you would, Josh.
I'll start with the parent plus because quite honestly, it's very rare to see a cosigner on a parent plus loan. Now, a Parent Plus loan is one that a parent takes out for a child that is an undergraduate study. Now, here's another sign. If you, the student, are a cosigner, or mom or dad is a cosigner, it's a parent. It cannot be a Parent Plus loan because the student can't cosign on a Parent Plus loan for themselves. There could be a Graduate Plus loan. That many times, either a parent or a spouse will be an endorser, cosigner, but those are also still rare. So you're absolutely right, Brad. When you hear cosigner, I think private loan. Why? Because it's credit worthy, and most federal loans are not based on credit, so you don't need a cosigner. Only plus loans are, so you might need a cosigner. I think this is a private loan. Brad, you're correct. So back to what was the question again? Now that we know what's
well, the question is, what could I do to protect my cosigner if I'm not going to be able to make the payments?
I would say you need to call Brad, because the only real protection you get for a cosigner on a private loan is a Chapter 13 automatic stay. It's
Right.
very hard if you can't make the payment.
So for our viewers, and thank you, Josh, for the plug there. But if you do have a cosigner, you're worried about that loan that you're unable to make payment on impacting a cosigner, a Chapter 13 personal reorganization bankruptcy is not going to get rid of the student loan in most instances, but it'll allow you to protect yourself from that student loan creditor, and in most cases, protect your cosigner also while you're in the Chapter 13. Now, Josh, that's the second time I've talked about it's difficult to discharge a student loan in bankruptcy, and you may not be able to get rid of the student loan to a Chapter 13 bankruptcy. And I think you've nodded your head a little bit both times sideways. So, what's been your experience with student loans in bankruptcy?
Without getting too deep into the weeds, I believe there is a very, very important difference between a federal loan and a private loan when it comes to a bankruptcy discharge action or an adversary proceeding. Federal loans are hard to discharge. And my first question is, what is your income-driven repayment? And if you tell me it's only $5 a month, we're not getting a discharge because you can afford $5 a month. What I like to do is juxtapose that with a private loan. Private loans don't offer you a payment based on income. It's there. They have two payment plans: pay or don't pay. That's really your choice. And from my experience, this is not for everyone, but I actually find a Chapter 13 can be useful, and filing a discharge action can be useful, not necessarily for a full discharge, but it gets a talking head to start settlement discussions. And that is where you can definitely protect the cosigner, because you can get into a settlement discussion, get into terms with the payment plan that you can afford. All of your cards are on the table because, correct me if I'm wrong, Brad, but you have to give them your budget and all of your finances in a 13. So the lender comes in knowing exactly what you've got and what you don't. So settlement discussions, I find, are very fruitful through a 13, and very useful way to protect your cosigner. The lender gets some money, you get to keep some money, and both sides can actually work. Again, it's very fact specific, but I do find that that's a very useful tool that can work in a 13 is that adversary for settlement.
I would agree. And for our viewers, you're going to have better luck with this in some bankruptcy courts than other bankruptcy courts. And, for instance, Josh, even with the income-driven repayment plans, often if somebody is in a Chapter 13 bankruptcy, they're not even allowed to subclass, without getting into the weeds here, but they're not able to treat that loan separately for bankruptcy purposes. Um, that there are certain things we can do in getting you into a Chapter 13 to begin with, and we had the same conversation about the end of the mortgage foreclosure forbearances, getting you into a Chapter 13 so you can get some initial protection and then try and come up with a plan is often a good first step. Josh, we are nearing the end of the hour here, and there are two things I want to do. I'm going to ask you one more question, but just so you're prepared, I'm also going to give you a moment at the end of this conversation to pitch in with anything that you may have forgotten here that's important. The question I think a lot of people want to know is, what can we expect with the current presidential administration, or with uh, our government in the future with respect to student loan debt. It's a big, big problem, and it's one that's
Yeah.
going to need to be addressed. What do you think is going to happen?
So I'll get through this quickly. Number one, the administration has been talking about a $10,000 forgiveness. I don't think it's going to be more than 10. I do think the 10,000 will happen. I actually think it'll happen in August or September. They need to do it before the midterms, politics aside. Two, the Department of Education came out with a list of things that they want to redo. One of them is the borrower defense to repayment if you think you were defrauded by your school. So pay attention for that. Two, they're looking at redoing the entire income-driven repayment plan, scrapping the 5 plans we have, coming up with one new one with an even better, friendlier formula. Watch out for that. That can take the next 18 months, but be aware of it. And the third thing I want to touch on, actually the fourth thing, they're looking at revamping the public service loan forgiveness as well, so that instead of it being a 10-year all or nothing, every 2 years you receive a percentage, so that by the time you reach the 10th year, all of it's forgiven. But if you only do public service for 2 years, you get 10% forgiven. 4 years would be 20% forgiven. So pay attention for all of that. The Department of Education really came out with the laundry list of things that they want to revamp, and some of it they've already started on through what's called negotiating rulemaking to make changes, official changes, not just policy, but actual regulation changes. So
I think
that's what I
changes
see.
to changes to the public service program would just be wonderful. Encouraging people to go into public service after they've completed their education is not a bad thing.
No.
It certainly would be helpful for our country and many of our communities, and students with large student loan debt. But I interrupted you there. Let me give you a chance to finish your string of thought there.
No, that's really what I see coming. Other things that are not as common, there are some folks that unfortunately have spousal consolidation loans where they were allowed to put both of their loans together. There's no exit ramp. They terminated the program in 2.6, but they didn't put an exit ramp, so you're stuck. There is also talk of somehow allowing them to be split, whether it's only in a divorce situation or something, but to allow split consolidation so that people can get their lives back on track and fully enjoy their divorce is really one of the issues that we're seeing here. Also, people that have an FFEL spousal, they don't get public service loan forgiveness because they can't bring it over to direct loans. So there's a lot of good things that I see coming down the pike. It's going to take a few months to see it fleshed out, but I think by the end of the summer, we're going to see some things really starting to blossom.
I hope that's the case. We certainly need help. A lot of people with large student loan debt need some assistance. I want to tell our viewers before we finish up here, student loans are an area that require, I think, a large amount of expertise. Josh is an excellent resource. We provided his contact information. At the Bond and Modus Law Offices, we like to try to maintain relationships with a variety of different experts in their fields. We encourage you to reach out to us with any type of legal problem, with any question. If it's something we can't help you with, we'll help you get to the right resource, to the right person. If you want to learn more about Josh, I encourage you to go to my partner, Ron Sixtus's podcast. It's featured on our website. It's called Next Lawyer Up. And Ron approaches his podcast a little bit different than what I do here with Facebook Live. In that, we learn more about Josh and about his background and his experiences. And it's really a fascinating listen. So I encourage you, go to our website, go to our podcast, and you can find the interview that Ron did with Josh there for more background on Josh. I was with Ron in Chicago at that NCLC conference in 2011 when I first met you, Josh, and you really opened my eyes up to relief that's available for people, and I've learned a lot from you since. I want to thank you for your time, but I want to give you a chance here at the end. Is there anything important that I may have missed that you want people to know about dealing with student loan debt?
No, the only thing I can tell people that's really important now that the CARES Act is set to expire is pay attention to your mail, pay attention to your email. And if you're not sure, contact your servicer. And just stay on top of it as best as you can, because honestly, nobody knows really how this is going to end. And any major announcements will get very good press coverage. So just pay attention to what's going on.
Absolutely. I keep telling our viewers, you've got to be proactive. You've got to reach out and help yourself. There are people like Josh that can help you. We want to help you at the Bond and Bodas law offices, but you can't ignore the mail. You can't ignore communications. You can't stick your head in the sand, folks. Now's the time to get out, ask for help, protect you and your family. Josh, one last time, thank you for joining us today on Facebook Live. I appreciate you and the work you do. To our viewers, Josh wants to help you. We want to help you. At Bond and Bodas, we care about you. We try to treat our clients like family, and we look forward to seeing you again next week. Thank you, everybody, and thank you, Josh.
Thank you.